Next case on the docket is 24-2185 Compass Bay Townhome Association Incorporated versus American Builders Insurance Company. Counsel, we normally leave 5 minutes for rebuttal, but we can do more or less if you prefer.
5 minutes is fine, Your Honor.
All right, counsel, proceed when you're ready.
Good morning, Your Honors. May it please the court. My name is Samuel Alexander, and I represent the appellant in this case, Compass Bay Townhome Association. This court should reverse and remand for two reasons. First, the trial court erred in its interpretation of the townhouse project definition when it improperly struck 2/3 of the definition as immaterial. Second, the trial...
I did notice that 63% number. Was it 63 or 67?
It was 63, I believe.
It was an interesting way to write it, because I took your point about the language, but I wouldn't normally think of how we would... I wouldn't normally look at it in terms of the percentage of the words that weren't given effect. I mean, I would look at the words and whether you're giving full effect to the text, but that percentage as a device was something I haven't seen before. Is there anything that says something that kind of we look at the percentage of the text that was given effect just in terms of the number of words, or was that just kind of an argument you decided to go with?
It was just I thought it was a persuasive device to demonstrate how much of the provision was struck.
So you don't think there's a certain percentage that makes it material or non-material?
No.
You just...
I think what's important is that the portion that was struck, the 63%, contained an entire element of the definition that the parties agreed.
Oh yeah, no. So the fact that, and I get your argument that a huge chunk of the text was not given meaning. It was just that percentage device. I was wondering if there was anything more particular that it came from.
No, it's not actually material. The second reason this court should reverse is that the trial court erred in ruling that the parties' interpretation that they agreed upon was unreasonable as a matter of law. In fact, the parties' agreed interpretation was the only reasonable interpretation. They agreed that the definition had two elements: one, a physical description portion, units with shared walls, and two, an ownership structure portion, which provided with other parts or portions of the development being owned in common by the unit owners. Because the common elements were not owned by the unit owners, the exclusion does not apply, and therefore Security National was required to indemnify. As for the Tipsy-Coachman argument, as an initial matter, we think there's insufficient factual predicate in the record to grant Tipsy-Coachman relief. They never requested summary judgment relief on a duty to defend. The trial court never made any findings on a duty to defend. But it's ultimately immaterial because the Florida Supreme Court in CTC held that the duty to indemnify is not dependent on the duty to defend. They're independent duties. The duty to indemnify is determined by looking at the underlying facts of the case, and the duty to defend is determined by looking at the allegations. In this case, because there was a duty to indemnify under the underlying facts of the case, regardless of the allegations, Security National had to indemnify, and the exclusion does not apply because the unit owners don't own the common elements, so this court should reverse and remand for further proceedings.
Is a corporation not one way for something to be owned in common? Would you say that's a mechanism for things to be owned in common? Isn't
No.
the whole point of a corporation?
I think that the unit owners don't own. They own shares, or they're members of the corporation, and the corporation owns the assets. I don't think that you can say that the unit owners own the corporation's assets because they're members of the corporation. And I think that's kind of black letter corporate law, whether it's an LLC or a corporation or an association. And I think the legislature recognizes this difference as well. In Chapter 718, you have the condo statutes, which hold that unit owners have a direct, undivided share of the common elements. And in Chapter 720, which Compass Bay is incorporated under, it provides that generally an association is going to own the common areas, although that's not necessarily the case. But there are practical differences between who owns the common areas legally with regard to decision-making, standing to sue for defects, how the common areas are managed. And Security National wrote a very particular, very specific exclusion.
It would seem to me to be a little, if an insurance company wanted to provide an exclusion for townhome communities, it would seem to me to be a little odd to make it turn on how their common elements are owned. right? I can't imagine a way the insurance company would have, it would matter to them which way they were owned in terms of wanting an exclusion. Is the thrust of your argument kind of the underlying assumption that, yeah, they may have intended to exclude this, but they did a bad job drafting and they paid the price?
No. I think that they wrote a very specific exclusion, and why they did that, I agree, it is a very odd thing for them to have done.
I'm not saying that argument's wrong. I mean, sometimes
But-
you draft a contract wrong, sometimes you gotta live with it, but I'm just saying, is that not the underlying thing here, that they probably intended to exclude this, but they didn't do it effectively, and they owe coverage?
I don't think we can make any assumption on what they probably intended. The only thing that we can assume as to intent is what they put in the contract. And what they put in the contract is that coverage is excluded when you have a development with units with shared walls, and other parts and portions of that development are owned in common by the unit owners. And sometimes under Chapter 720, that's going to fall their way. Under Chapter 720, there are, the association does not always have to hold title to the common elements. Sometimes the unit owners do. And so sometimes it's going to fall their way and there's going to be coverage. And sometimes it's not going to fall their way, and sometimes it'll fall their way and it'll be excluded, and sometimes it won't fall their way and there will be coverage. What I don't think they can do is write this very specific and very clear exclusion, and then there's a case where it results in them being required to provide coverage, and they say, well, that's not really what we meant. You know, these unit owners essentially own the units in this case. I think the court has to look at it from the perspective of someone reasonable reading this provision, and if you're a developer and you're reading it, or a subcontractor, and you say, okay, am I going to be covered by this insurance policy? And you look at the first element, you say, okay, units with shared walls. And you look at the second element, and you say, okay, with other parts or portions being owned in common by the unit owners, so let's go to the covenants and declarations and deeds, and let's see who owns the common elements, and it's not the unit owners, and you go, okay, so there's coverage. And this was the understanding of the provision that the parties had before the court kind of sua sponte ruled that 2/3 of the provision was immaterial, or I guess the second element of the provision was immaterial. And in doing that, the trial court violated the canon against surplusage, which provides that courts should strive to give meaning to every word in a provision if possible. And not only did the court's interpretation render the entire second element of the provision surplusage, but it also, in effect, renders a lot of the other exclusion surplusage as well, because it leaves a very, very broad exclusion, which says coverage is excluded for any development with units with shared walls. So then, all of a sudden,
there's a question about how the duty to indemnify versus the duty to defend would have worked out in practice, because I take your point, they didn't move for summary judgment on that. I'm not asking about that. I take your point. And, you're right, it was not in their motion for summary judgment. But putting that issue aside, if the insurer would have gotten this, they would have looked at it, and the complaint would have put it squarely within the exclusion, and so they would have denied the defense properly. How would the duty to indemnify ultimately have kicked in, right? If they get a complaint, which they have every right to deny, does the case then just get litigated, and then ultimately, if there's some judgment, you have a right to give them notice afterwards when they now don't have a chance to defend it? Because I'm thinking, your client has the rights of the assignee of KB Homes, and so I'm thinking, how would this have actually worked with KB Homes being able to enforce it, since you're enforcing their rights?
yeah.
And would it have been that they could totally, properly have no duty to defend, deny defense, and then have no chance to defend because they didn't know they needed to, but then get a judgment at the end and have a duty to indemnify? Like, how would that have worked out mechanically? You could end up actually having liability for indemnity without ever having an opportunity, not just a duty to defend, but really never having an opportunity to defend.
Well, I think nothing's, they made a decision, presumably not to defend. They could have done their own due diligence and determined whether or not they thought ultimately, under the facts of the case, there was going to be coverage.
As a matter of insurance law, though, how does that work out? I mean, do they have to do that? Are they not entitled to look at the complaint and say whether this is seeking liability for which we are liable?
They're entitled to make,
to investigate?
but that is limited to the duty to defend, ultimately.
I guess
Counsel, would it be more, I guess, in a motion to dismiss, failure to state a cause of action, because on the elements it wouldn't satisfy that, or is it? properly done under a summary judgment.
Do you mean in the underlying case for a failure to defend, or in a subsequent case for a failure to indemnify?
I guess under either.
Because I think in the initial case, I'm not actually honestly sure about what the facts are, because it wasn't developed in summary judgment of
Fair enough.
whether defense was requested and whether it was denied and on what basis, or if it had anything to do with this allegation. But in terms of a practical matter, I think what we're left is with the Supreme Court's holding in CTC, which says that the duty to indemnify is separate from the duty to defend. And I think that that case is very instructive. In that case, you had a developer who was sued by his neighbors for building on a setback when he claimed that he mistakenly thought he had obtained a variance. And he requested defense and indemnity from his insurance company. The insurance company said no. Under the facts alleged, you engaged in intentional conduct, and so that's not covered. And he said, well, it was a mistake, and ultimately they went on summary judgment. And the First District Court of Appeal reversed. Well, his mistake is something that falls under the policy. If a jury believes that this was a mistake, they could find that there's coverage under the duty to indemnify. And the Florida Supreme Court affirmed that decision and said, yes, same. If this was a mistake, that falls under the policy. And if a jury agrees with his version of events, there could be a duty to indemnify. But notably, they said, we cannot decide the duty to defend. The duty to defend is a separate duty. It's determined by the allegations in the complaint. We don't have the record before us to develop that. So that's an open question, and on remand, that can be determined.
Counsel, I'd like to maybe turn to the text of the townhouse project provision or exclusion. And I guess looking at it, I guess I wonder if there had just been an additional comma in there, would this have kind of muted out this whole dispute?
That would have made it clear, but I think that the trial court also came with kind of a rule that it seemed like it was maybe just a misunderstanding of how these things worked, and he thought that wherever he said during the hearing, a townhouse project consists of a development with one or more units connected by shared walls with other parts or portions of the development. And he said, well, that's an independent clause, meaning that's a sentence. So I think that's where the material language ends. So he also believed that the material language, based on that reasoning, the material language of a provision stops wherever the first sentence stops, and then
I have
everything
trouble trying to
after that.
figure out what the trial court meant, because it leaves that the last part of it with other parts or portions of their own development just kind of standing alone, and it seems kind of nonsensical. Did you? I read it many, many times in the trial court's ruling, but I was still having trouble figuring out what the trial court thought with other parts or portions of the overall development meant. What was your understanding of what the trial court thought the work that clause was doing?
I honestly don't know. And I think it's clear from the neighboring definitions that the with language connects to the second element, the ownership portion element. So you have a description that's a physical portion description that says the units or housing units with shared walls, and then you have another portion that says with other portions being owned or without co-ownership, or so that the with clause or the without clause in one case is the beginning of a subordinate clause that is the entire second element.
I have a question. You mentioned the canons. It's hard to say that it's a plain meaning because this is not that clear, but do you think we even get to the canons when you read it that way, that we just look at this language and know that what the project says can't make sense because none of those things orderly don't leave out substantial portions of that paragraph?
I think if you just apply the rule that you should interpret a contract by its plain language, we win.
Even though it's not really plain, it's plain enough that we don't have to
It's plain enough, and it's through process of exclusion. But it helps to have a canon that says, these words in this provision, you should try to make sure that they mean something if possible. And it's very easy to make them mean something. And then the whole text canon helps a lot when it says, why don't we look at the other provisions and see how they're structured, and they're structured in such a way that the only possible conclusion is that this is a two-element provision. I did want to say one more thing about the Coachman argument in terms of the duty to indemnify and the duty to defend. In CTC, the Florida Supreme Court could not have reached the determination that it made, that a jury could find that there was a duty to indemnify, while still ruling that there's a potential that there was no duty to defend based on the allegations, without a finding that the duty to indemnify was not dependent on the duty to defend. And that holding has been held by the Fifth Circuit Court of Appeal in Gilbane, which cited the Texas Supreme Court. And the Texas Supreme Court said very clearly the duty to indemnify is not dependent on the duty to defend. And this relates, I'm going into my rebuttal time, so I'll reserve the rest.
Thank you, Counsel.
Good morning. Josh Levy on behalf of Security National. As I was preparing for this oral argument, and I was wondering why this court would choose such a dry case about insurance law and contracts, I was speculating that the court might want to witness how an attorney might maintain its credibility defending an order on appeal where the trial court rejected the appellee's arguments. And let me just say this. In this case, the party's interpretation differed from the trial court's interpretation. But this departure is not grounds for reversal for three reasons. First and foremost, no one disputes that this is a development of two or more individual housing units connected to one another by one or more walls with other parts or portions of the overall development. So what was constructed and what the insured's liability arose out of were its construction operations.
Hold on, when you say nobody disputes that, to what extent are they not disputing that with other parts or portions of the overall development? Because under the trial court's interpretation, I'm not even sure what that part means. So when you say nobody disputes that that whole part applies, including the with other parts or portions of the overall development, what is it everybody agrees to as to the with other parts or portions of the overall development?
To be fair, we did not advance this interpretation.
All right, but you just told me you're going to defend it with
No.
credibility. You specified.
I believe it's textually permissible because what the trial court was doing was it was saying that it didn't create surplusage. It just interpreted the word including as including but not limited to. And so the notion that it somehow deleted the second part of the exclusion is not fair.
All right, counsel, I asked you a specific question, though. So you told me everybody agrees that this meets the language of the provision up to the word including. Okay? You read the whole part up to the word including, and you said everybody agrees that that is satisfied. And what I'm asking is, that includes the with other parts or portions of your overall development. Without the parts after the word including, I cannot tell what with other parts or portions of the overall development means. So when you say that everybody agrees that was satisfied, what is it everybody agreed was satisfied as to that provision? What does it mean? What does the with other parts or portions of the overall development mean that everybody agrees to, as you said?
The court was simply giving examples of what other portions of, I think that my friend agrees that there are other parts or portions of the development, including common areas, buildings, land use.
Yeah, no, I get it. So you're saying that the including is examples of the with other portions. Okay. But if you don't connect the with other portions to being owned in common, then I don't understand what meaning with other portions or portions of their overall development could have.
And maybe, and I know it's always not favored as a litigant when judges ask two line of questions at the same time, but if the period basically that the trial court seemed to use goes right before the word including, why does that not render the second part of that first sentence a sentence fragment or an incomplete sentence? Because as Judge Mize is alluding to, it almost begs the question, what is with other parts or portions of the development, overall development, now connected to? What is it referring to? It doesn't seem to just refer to that first part of the sentence.
It's referring to building structures, land, and other examples. It's a the court, I believe, said that this is a non-exhaustive list.
No, I get that. I get that. But like, even if you said with other parts or portions of the development, including building structures or land, what would that even mean? without adding on at the end, being owned in common, even including those examples, the phrase has no meaning.
I believe the trial court applied the canon, the presumption of non-exclusive include canon.
Counsel, I've asked you 4 times for the meaning of this phrase, and I've yet to get a meaning out of you. What is the meaning of that phrase?
Again, Your Honor, all I can tell you is that it's,
Is the answer that you can't think of a meaning? If that's fine, just tell me the answer and I'll move on, but I'm not going to move on until I get an answer. If the answer is, I don't know, I can't discern a meaning under the trial court's ruling, that's fine. But if there's a meaning, I want it. If you can't give me one, I'm going to assume that you agree there's no meaning to that clause under the trial court's interpretation.
I'm just going to go back to what I believe the trial court was doing, which was, it was simply just, it didn't leave that clause hanging out there, okay? I think that, what we're assuming is that, after the townhouses, which is the first clause, it was simply just giving examples of the other parts and portions of the development.
But then that leaves out the being owned in common by all other owners of separate individual housing units. One way or the other, it's leaving out something that appears to be pertinent.
I think that assumes that the building structures and land are all common owned, and that isn't necessarily so.
So counsel, I know you mentioned the trial court kind of hinged its analysis in large part on the word including, being kind of a word of expansion, of examples, and that is typically or often how that word is used. But when we look at the whole provision, why does that interpretation, what is your argument that that should be the primary one here, when, it seems like, as we're saying, it's maybe disconnecting that second part of that first sentence if we do that.
I think the first part, if you look at development of 2 or more individual housing units and it goes on, I think development of is what's required, right? It's consisting of. Whereas the second clause where it just says including, I don't necessarily think that we can assume that every townhouse project is going to include every structure that's listed here. Could you sway me?
No, I take it that the including is examples of the other parts or portions of the overall development. I think that's correct. But even including that as the examples, right? Even say that's a list of examples, it would still be an incomplete clause that doesn't appear to me to have any meaning unless you then connect that to being, and other such common elements being owned in common. So,
I think
because your argument in the brief was that was the only reasonable interpretation.
it was.
And I don't fancy myself an Einstein, but I'm having trouble figuring out how that works. And I've asked you 5 times to tell me what it means, and you haven't been able to. Can it really be possible if I can't figure it out, and you can't figure it out, that it's the only reasonable interpretation?
Well, to be fair, I didn't say that the only reasonable interpretation was the trial court's interpretation.
I thought your brief did say that.
No, actually what I said was that it's textually permissible. It's potentially reasonable.
Okay. Do you dispute that if you have multiple reasonable interpretations, we have to construe it in favor of coverage?
I do dispute that because under Florida law, if you're going to apply that rule and it's actually ambiguous, it has to actually be ambiguous, so we have to apply the exclusion. And in this particular case, I don't believe when you apply the exclusion, I guess the rule is an ambiguous provision creates more coverage and restricts coverage at the same time, right? You don't just stop at that rule. And so I think that our argument is that even if you construe it the way the parties construed it, it's not ambiguous as applied.
And what is the reason for that? Is it because you're saying there are 2 reasonable interpretations, but yours is more reasonable, therefore it's not ambiguous? Because I guess when I traditionally think of ambiguity, I think that there are 2, not just permissible, but reasonable interpretations, and it's not really sure which one is which, therefore we find ambiguity. So I guess what is your position of why ambiguity doesn't apply?
Because if there are 2 reasonable interpretations, when you apply both interpretations, One interpretation has to create coverage, and one narrow coverage, and one expand coverage.
Where does that, I don't recall that, where does that rule come from?
I believe in Auto Owners versus Anderson.
So something is only ambiguous if it appears to both grant coverage and take it away? That's what ambiguity means?
Yes, and that's what Judge Alvaro held in the non-preserved case.
So let me ask you this,
And
then,
which court is that from?
It's a trial court.
Okay.
so let me ask you this, then, what is it, if ambiguity means when a provision both takes away and excludes coverage, what do you call it just when a provision has two reasonable meanings, if not ambiguity?
I think in the statutory context, that's correct. But in the insurance context, still ambiguity, it could have two reasonable interpretations and Compass Bay could still be excluded.
I guess I'm having trouble then distinguishing why we wouldn't apply that rule from the statutory context, which is just general principles of how we interpret language. Whether it be a contract, an insurance provision, a statute, the same general principles of grammar and syntax and our usual rules of reason would apply. And I would tend to think, unless there's some higher precedent that says we shouldn't, that we would just apply, if there's two equally reasonable interpretations, then that means ambiguity.
I fear I'm going to repeat my answer.
Understood. You can go.
I mean, we can agree to disagree. So with two textually permissible interpretations, the question is, what does the court do with that? If we're going to apply the canons of interpretation, I think we can look at the supremacy of the text. And in Scalia and Garner, what they say is that you can. Bear with me a second. You can look at the purpose of the contract, right? So the purpose sheds light only on deciding which of the various textually permissible meanings should be adopted. So what is the purpose of the commercial general liability policy? It's to cover the operations of property liability arising out of property damage caused by the insurance operations. So if we're going to focus on the common elements, and this is what the judge below said, the insurance liability doesn't arise out of ownership of the common element.
Is that going to go to the question I started out with your opposing counsel of his argument, kind of the underlying assumption being, I'm not saying it's right or wrong, but the underlying assumption of their argument is, yeah, they probably intended to exclude this, but they didn't do an effective job of it. The language doesn't exclude it, so we get coverage. And you're basically saying, at least look at the purpose and say there was not supposed to be coverage here, right? Like, they were clearly trying to exclude it, and so we should interpret it in a way that they succeeded in doing so.
If you take the interpretation to the extreme, okay, I think what my colleague is saying is that this only excludes coverage if it's a town-home condominium association. It doesn't exclude coverage if it's a town-home homeowners association. And respectfully, I think that leads to absurd results. It's the same damage. It comes out of the same work. The liability is formed long before any of these associations.
Am I right then? Very basically is they were clearly trying to exclude this, interpret it in a way that affects that intent.
I'm not saying you're wrong. What I'm saying is that it would just be bizarre if they were focusing the exclusion solely on what type of community association it was.
Well, counsel, I guess going back to the supremacy of text principles, so we're supposed to look at the text in its proper context and find its fairest or best reading. And I know you're talking about the intent of the parties in drafting, but the best evidence of intent is the plain language. And regardless what parties intend, people are bound, and legislatures are bound by what they say, and people should be able to rely on a reasonable interpretation of that, from a common listener. Be that as it may, I guess just from an intent side, I'm struggling to see if that was the intent, why not just strike everything from being owned in common thereafter to then effectuate that purpose? Because then you would still have the including, giving you an example, but then you're taking out all this talk about commonality of ownership. So what purpose did that have, and if that was truly the intent?
I think potentially, if it just says a development of individual townhouses with other portions or parts of the development, that potentially could be problematic. Who knows what my colleague would argue is that it doesn't include portions of the property.
Yeah, one thing I found with counsel is that the provision, discusses the idea of a corporate entity in the context of managing the property, but not owning it. And that would seem to me to imply that the text clearly contemplates that there might be an entity, but nonetheless said the common elements must be owned in common. It didn't say owned in common or through an entity, even though an entity is mentioned in the context of managing the common elements. Does that hurt your side of the case? It's not like they didn't think to talk about corporations. They did.
They did.
And you would think there must be some meaning to that distinction.
Well, I think the plain reading of the text is it just doesn't matter if there's an association.
All right. Just a final point about it. So am I correct that it is your position that the interpretation both sides gave below is a reasonable, permissible interpretation? You don't think it's the best one, but you agree it is a reasonable, permissible interpretation?
I do.
Okay.
Yeah.
So there is, in fact, more than one reasonable interpretation of this provision in your view?
It is. I believe the trial court gave the best interpretation.
Yeah. You think trial courts is better, but you agree that there is more than one reasonable interpretation of this provision?
Correct. And again, and I respect the court, but I've only cautioned that you need to apply the exclusion as well in order to determine whether it's ambiguous.
Understood.
And
Okay.
okay. And in this case, when you apply the exclusion to Compass Bay, it is the second clause also excludes coverage. Why is that? It's because Compass Bay in its own pleading says, and you pointed this out before, that the exclusion applies because Compass Bay says that its unit owners collectively own the common elements.
Well, you can tell from my discussion with your opposing counsel, I'm interested in how that would have worked out. But one thing you brought up, which seems to be correct, I read your motion for summary judgment, page for page. It did not move for summary judgment on this basis. And the exact type of questions I was asking, we don't know the answer to because they weren't developed on summary judgment. So we can tipsy coachman when the basis for affirming is supported by the record. And when we're tipsy coachmaning a summary judgment, if the basis for the tipsy coachman is something that would have had to be included in the motion for summary judgment in order to be a subject of summary judgment by the trial court, doesn't that mean that if it's not in the record, if it wasn't in the motion for summary judgment?
The principle is in the record because it does say that the duty to defend is broader than the duty to indemnify, and we certainly did advance that the complaint was evidence of lack of duty to indemnify.
But you have to file a motion for summary judgment a certain time before the hearing. I mean, there are timing and requirements you have to do. It's not like you can just go to the hearing and say things, right? And so if we were to tipsy coachman on that basis, when you didn't move for summary judgment on that basis, wouldn't we be bypassing the requirements of the summary judgment rule?
And aren't complaints allegations and not evidence?
I think that if there's no duty to defend, there's no duty to indemnify, right? So here our position is that there wasn't a duty to defend. I think Your Honor asked initially, well, how does that work? So the claim is tendered to the insurance company. The insurance company reads the complaint. The allegations fall squarely within the exclusion. Well, what happens then? Does a settlement occur and then the claimant or the insured is come back and say, here's a settlement. You need to indemnify it. And that's not the law.
But you agree there's nothing in the record about how that would have worked out in this case, right?
It's in our summary judgment motion that the duty to defend is broader than the duty to indemnify.
Can I ask you one question for your time runs out? It does seem like, in terms of the manner of the ownership, and I think the trial court comment on this, that there wasn't a cross motion for summary judgment here, but it doesn't seem like there's any issue of fact here in terms of the ownership. It doesn't seem that anyone disputes that the common elements were owned by the association. You just dispute assuming their interpretation and your former interpretation applies, you dispute whether that constitutes common ownership by the unit owners under this exclusion. You say that ownership by an association qualifies, and they didn't have to have direct ownership. But it doesn't seem like there's any dispute as a factual matter that the common elements were owned by the association, correct?
We presented evidence that in order to convey the common elements, there needs to be a vote of the members. And so to say that it's not like a normal corporation where the stockholders,
But that actually is like a normal corporation. There's lots of corporations that certain transactions have to be approved by the shareholders. That's like a very common thing in corporations, right? They vote on the board meetings. If you want to sell essentially all the assets or certain assets, that actually is like every other corporation, or at least many corporations. That's a very common provision in corporate law to require shareholder approval for certain transactions.
so the shareholders can get in and out of the corporation when they want to. These are members of an association. They have to pay dues. They have to live there. They have to be part of the association. So they do have some interest in how the common areas are, in this case, conveyed.
I guess what I'm saying is the mere fact that the members had to approve sales of certain property doesn't mean they own the property, just like the shareholders of Coca-Cola don't own the bottling plant just because there's some provision that says Coca-Cola can't sell its bottling plant without shareholder approval, right? That doesn't mean the shareholders own the bottling plants, right?
I take your point.
So I guess I'm asking, is there a dispute that the association owned these common elements? Do you think the evidence showed a factual dispute on that?
I do think.
All right, thank you.
Thank you, Your Honors. So I think it's important to note that my friend on the other side has conceded that the parties' agreed interpretation was reasonable. In that case, if there's a reasonable interpretation that excludes coverage and a reasonable that grants coverage, the court should construe in favor of coverage. We maintain that the parties' agreed interpretation provides coverage because there's no dispute that the unit owners own common elements.
And counsel, I guess regardless of the party's position on that, that's still just a matter of law for us to determine, correct?
Correct. But I think between the whole text canon and analysis of the neighboring definitions, just an application of standard rules of grammar, what does the with connect to? If it connects to the first part, what does that do with the word including? If including is attached to with, then what is being doing standing there? The only way to make sense of it is for with to connect to being, just as it does in all of the other provisions.
So as counsel, does this reading require us to imply a comma that's not there?
No, I don't think so. I think that...
And if so, is that a problem?
I think that it would help if there were a comma, I believe, before the word being, but I think that there's no one rule that trumps any of the other rules, and you have to read all of these in conjunction with an application of common sense as a reasonable person.
In other words, just because it could be more clear doesn't mean it's not clear.
Correct. And on the duty to defend versus the duty to indemnify, I just wanted to stress that as like a policy matter, I don't think that a defendant who has an insurance policy should, their ultimate determination of whether or not they're entitled to coverage under their contract with their insurance company should be dependent on allegations made by a non-party to that contract against that defendant. So I think if we were to take a hypothetical of, let's say, you're a homeowner and you have a homeowner's insurance policy, and one of the trees in your backyard rots out and falls over and hits your neighbor's roof and crushes their roof, and they sue you, and in their allegation they allege, let's say falsely, that you have a dog, and for some reason your insurance policy says that if you have a dog, there's no coverage for anything that happens on the property. And then you ultimately settle with your neighbor, and then you go to your insurance company and you say, hey, there was negligence, there was an accident, I'd like to be covered under my policy. And they say, well, you have a dog, so you're not covered. And you say, I don't actually have a dog. And they say, well, your neighbor alleged in a previous suit that you had a dog, and so there was no duty to defend, and so there can't ultimately be coverage under the policy. I don't think that a non-party to this contract's allegations on information and belief can ultimately result in whether or not an insurance company is required to provide coverage that should be based on the facts as they are. And I think that's what CTC holds, where it says that the duty to indemnify has to be based on what the actual state of affairs in the real world is, whereas the duty to defend is based on the allegations in the complaint, which makes sense because that's what puts the insurance company on notice of what's potentially at issue in the case. The Gilbane case from the Fifth Circuit Court of Appeals holds the same. D.R. Horton from the Texas Supreme Court holds the same. The WellCare case from the Wisconsin Supreme Court holds the same. Seventh Circuit Court of Appeal, Keystone holds the same. And they mention the kind of note that theories of liability can be shifting throughout the course of litigation. You know, often people plead intentional conduct. Maybe there's a settlement, it turns out, based on an admission that there was negligent conduct. Just because there was no duty to defend in those cases doesn't mean that there's not ultimately coverage under the policy as there is in this case. So for those reasons, we respectfully request that this court reverse and remand for further proceedings.
Thank you, counsel.
Thank you.
All right, we'll have another question and answer session.